Step away from the vehicle. Hands where I can see them.
Officer, I'm a federal judge. My credentials are in my wallet.
The command rang across the parking lot for her to step away from the vehicle and show her hands. The woman complied, hands visible, key fob glinting in the afternoon light. The officer issued what he stated was her last warning. She wasn't panicking, wasn't pleading. Her voice remained level, measured, the tone of someone who had spent 19 years weighing evidence, interpreting constitutional law, and ruling on the exact kind of interaction now unfolding in a Chicago mall parking lot. She informed the officer that she was a federal judge, that her credentials were in her wallet, and that this stop lacked reasonable suspicion under Terry v. Ohio. The parking lot security camera captured everything. Every word, every movement, every violation. And Officer Mark Daniels had absolutely no idea that the black woman standing beside the black Mercedes had presided over police misconduct cases, qualified immunity disputes, and Fourth Amendment litigation that had ended careers and cost cities millions. The woman loading shopping bags into her trunk wasn't a threat. She was Judge Donna Mulinax. And this encounter, captured on multiple phones now emerging from the gathering crowd, would trigger a federal lawsuit, a Department of Justice investigation, and systemic reforms across an entire metropolitan police force. But there was something else. Something neither Daniels nor the onlookers knew. Something that would make this wrongful arrest not just a violation of one woman's rights, but nearly a miscarriage of justice for an entirely different family, a family waiting for their day in court, for answers about a fatal police shooting, for a judge who could hear their case without bias. That judge was now being handcuffed in a parking lot by officers from the same department. The narrator paused to address viewers directly, noting that if they believed no one should be detained based on skin color and assumptions about who belongs near expensive property, they should subscribe and comment with their location. Those who had been stopped or questioned for no clear reason other than existing in the wrong place at the wrong time were encouraged to type that accountability matters. The story would get more intense, with consequences reaching further than anyone in that parking lot could have imagined. The Chicago afternoon carried the weight of early autumn, cooler air cutting through the lingering humidity, the kind of weather that made parking lot asphalt shimmer, where sunlight hit it and left shadows sharp-edged and dark. Traffic hummed along the perimeter road. Car doors slammed in irregular rhythm. A woman emerged from the mall's north entrance, bags hanging from both hands, walking with the unhurried confidence of someone who had completed her errands and looked forward to nothing more complicated than the drive home. Donna Mulinax reached her vehicle, a black Mercedes sedan, clean lines and dark windows, and pressed the key fob. The trunk released with a soft mechanical sigh. She placed the bags inside with care, arranging them to avoid creasing, the movements automatic and efficient. She didn't notice the patrol car pulling into the row behind her. Didn't see the officer step out, adjusting his duty belt, scanning the lot with the particular attention of someone looking for something to justify the presence. What she did notice was the voice. The officer commanded her to step away from the vehicle. Donna turned. Her hands remained visible, one still holding the key fob, the other empty. The officer stood 15 feet back, positioned at an angle that kept his right side, where his service weapon rested, oriented toward her. His stance was textbook. His expression was harder to read. Suspicion, maybe. Or the kind of certainty that didn't require evidence, just assumption. She complied, stepping back from the trunk, keeping her movements deliberate and slow. Training kicked in, not the training of someone used to being stopped, but the training of someone who had reviewed hundreds of cases involving stops just like this one, who knew how quickly encounters could escalate when officers mistook composure for resistance. She asked if there was a problem. He moved closer. His nameplate read Daniels. His hand hadn't left the proximity of his weapon. That detail registered in her mind with the same clinical precision she applied to evidence review. Hand on weapon. No visible threat. No exigent circumstances. The first of many procedural failures. He explained they had received a report about a suspicious person in the parking lot. Black female, black Mercedes. The phrasing was careful. Not careful enough. Donna heard what wasn't being said. The absence of any articulated behavior, any specific action that would constitute reasonable suspicion. Just descriptors.
Race.
Vehicle. The kind of vague justification that collapsed under scrutiny but persisted because most people didn't know how to scrutinize it. She stated she was loading her own vehicle, that he could see her key fob, and that she could demonstrate ownership. She pressed the button. The Mercedes locked with a double chirp. Pressed again. Unlocked. The lights flashed in confirmation. Simple. Verifiable. More than sufficient to end a stop based on nothing. Daniels didn't step back. His jaw tightened. Something in the demonstration, the calm explanation, the legal awareness in her tone, seemed to irritate rather than reassure him. He informed her he would need to see her license and registration. She reached slowly for her purse, narrating her movements as she went, explaining she was retrieving her wallet from her bag and that her license was inside. The gestures were careful, hands visible at all times, the kind of choreography that shouldn't be necessary but was. She produced her driver's license and handed it over. Daniels examined it, checked the name against the registration she provided. The information matched perfectly. Her name, her address, her clean record. No warrants. No flags. Nothing that justified further action. He should have handed the documents back, apologized for the inconvenience, and left. Instead, he looked past her at the vehicle, at the shopping bags visible in the trunk, at the empty interior. He stated he would need to search the vehicle. The request hung in the air. No probable cause articulated. No consent requested properly. Just a demand dressed up as procedure. Donna's hands remained at her sides, but something shifted in her posture. Not defiance, exactly, but the unmistakable bearing of someone who recognized a constitutional violation in progress and refused to pretend otherwise. No Miranda warnings given. No arrest report completed at the scene. No articulated probable cause beyond the circular logic of uncooperativeness. The handcuffs were tighter than necessary, not painful enough to constitute excessive force by legal standards, but present enough to mark her wrists with red impressions that would photograph well as evidence. She made mental notes. Timestamps. Observations. The procedural failures were accumulating. The drive took 18 minutes. Chicago streets moved past the windows, storefronts, traffic lights, pedestrians going about ordinary routines, unaware that the patrol car passing them carried a federal judge in custody. The distance between normal life and detention was thinner than most people realized. One stop. One officer's decision. One moment where authority overrode procedure. The police station appeared ahead. A utilitarian structure of brick and concrete, functional architecture designed for processing rather than impression. Daniels pulled into the rear lot designated for official vehicles, parking in a marked bay near the entrance. He opened the back door without preamble, guiding Donna out with a hand on her arm. The gesture was mechanical, routine, the same way he had probably guided hundreds of people through this same entrance. Inside, fluorescent lights hummed overhead. The hallway smelled of coffee and old paperwork. Linoleum floors showed the wear patterns of decades of foot traffic. They moved through a series of doors, each requiring badge access, each closing with a heavy metallic click that emphasized the transition from public space to secure facility. The processing area was small and clinical. A desk. A computer terminal. Shelves holding plastic bins for personal belongings. A female officer stood behind the counter, her uniform crisp, her posture suggesting both experience and exhaustion. Her nameplate read Stevens. She looked up as Daniels brought Donna in, her expression neutral but attentive. Daniels provided minimal information: the stop, the arrest for interference, the basics required for intake. Stevens began the standard procedure, asking for identification and preparing to inventory personal belongings. Donna complied, her voice calm, providing her name and address without elaboration. Stevens removed the handcuffs carefully, placing them on the counter before gesturing for Donna to empty her pockets and surrender her purse. The wallet came out first. Standard leather, worn at the edges from years of use. Stevens opened it methodically, checking identification cards, removing items for inventory. Driver's license, credit cards, insurance cards. And then her hands paused, fingers holding a rectangular credential with an official seal. the seal of the federal judiciary. Stevens' expression shifted. Not dramatically, not with obvious alarm, but something hardened in her eyes, a recognition that this wasn't a standard intake, that whatever had brought this woman into processing shouldn't have. She looked up at Daniels, looked back at the credential, read it again, then reached for the phone on the desk, pressing an extension without explanation. The conversation was brief, professional, stripped of emotion but heavy with implication. She stated the watch commander needed to see this immediately. 3 minutes later, a man in a white shirt and tie entered, rank insignia indicating supervisory authority, expression suggesting a long shift about to get significantly longer. Commander Reynolds took the credential from Stevens, examined it under the desk lamp, compared the photo to Donna's face, checked the holographic security features that confirmed authenticity.
His jaw tightened.
Color drained slightly from his face. The kind of reaction that came not from fear exactly, but from the sudden understanding of consequences, of exposure, of decisions that couldn't be undone. Reynolds looked at Daniels, looked at Donna. The power dynamic shifted with almost audible force. He ordered her release immediately. The words were clipped, controlled, the tone of someone managing a crisis while trying to appear as though everything remained under control. Stevens moved quickly, gathering Donna's belongings, returning them with care that bordered on deference. Reynolds retrieved paperwork, incident reports, processing forms, documentation that would become crucial evidence. He handed them to Donna with something approximating an apology, though the words were careful, measured, stripped of actual admission. Reynolds stated there had been a serious mistake, that Judge Mullinax was free to go, and that they would provide her with copies of all reports and body camera footage. Donna accepted the documents without comment. Her expression remained neutral, but authority had returned to her bearing, not through aggression or demands, but through the simple restoration of what should never have been taken. She reviewed the papers quickly, noting officer names, case numbers, timestamps, everything that would matter later. She stated she would need all records, body camera footage from Officer Daniels, dashboard camera from the patrol car, all witness statements, and all internal communications regarding the incident. She specified this should be provided in writing within 72 hours. Reynolds nodded. The requests weren't suggestions. They were instructions from someone who knew exactly what documentation existed and how to compel its production. Stevens had already begun preparing the files, printing receipts, assembling the paper trail that would follow this incident through depositions and discovery and eventual settlement. An escort appeared to walk Donna out, not for security, but as courtesy now, though the gesture came too late to erase what had already happened. They moved back through the same halls, past the same doors, out into the parking lot where afternoon had shifted toward evening. The 2 hours and 23 minutes she had spent detained represented time that couldn't be recovered, dignity that couldn't be restored through apologies alone. The narrator posed a question to viewers, asking if they had ever been stopped by police for no clear reason and inviting them to type yes or no in the comments and share their stories if comfortable. The explanation followed that what happened to Judge Mullinax happened to people every day, people without federal credentials, without legal expertise, without resources to fight back. Officers escalated instead of listening. Assumptions replaced procedure. Bias became enforcement. The point was made that viewer stories mattered, highlighting why change wasn't optional but necessary. A squad car drove Donna back to the mall parking lot where her Mercedes still sat, undisturbed except for the shopping bags that had shifted slightly in the breeze. Her car keys were returned. No further explanation offered. The officer who drove her left quickly, avoiding extended contact, as though proximity to the mistake might somehow transfer culpability. Donna loaded the bags properly this time, closed the trunk, sat in the driver's seat. The leather felt familiar. The dashboard display showed the same time she had checked before the stop, though hours had passed. She started the engine but didn't drive immediately. Instead, she sat in silence, processing not just the arrest itself, but its implications. At home, she made the calls that needed to be made. Colleagues first, federal judges who would understand both the legal dimensions and the personal violation. Then civil rights attorneys whose work intersected with hers, who documented these patterns, who built cases around precisely this kind of misconduct. Each conversation followed similar beats: the facts, the violations, the next steps. Her tone remained professional throughout, clinical even, because emotional response could come later. Documentation came first. It was during the fourth call, to Judge Patricia Owens, a colleague who shared her docket rotation, that the complication emerged. Owens' voice carried hesitation, the kind that preceded difficult news. She pointed out there was something Donna needed to consider: the Westbrook case, the fatal shooting trial scheduled for next week. Chicago PD was the defendant. This arrest created a potential conflict. The words landed with precision. The Westbrook case. Antonia Westbrook, 23 years old, shot during a traffic stop 6 months earlier under circumstances that remain disputed. His family had filed a federal civil rights lawsuit. The case had been assigned to Donna's courtroom. She had spent weeks reviewing evidence, preparing for trial, ensuring that the family would receive a thorough and impartial hearing. And now this, her own arrest by the same department, the same systemic issues, the potential appearance of bias, not in favor of the family but against the defense. The kind of conflict that could force recusal, that could delay trial, that could push a grieving family's quest for answers back months or even years while a new judge was assigned and brought up to speed. The irony was suffocating. Her arrest for being Black could prevent justice for another Black family. One act of bias threatening to compound into further injustice. Donna stated firmly she wasn't stepping down. The words came with conviction. Donna had already begun mental calculations, ethics advisors to consult, precedents to review, arguments to construct. The conflict was arguable, not automatic. She could demonstrate impartiality, could show that her personal experience wouldn't prejudice judicial analysis, could proceed with the trial while simultaneously pursuing her own case. Difficult, yes. Ethically complex, certainly. But not impossible. And somewhere across the city, in the same police station where she had been processed and released, Officer Mark Daniels finished his shift, wrote his incident report, logged the arrest as interference with investigation, unaware that the video from the parking lot had already been uploaded to multiple phones, that copies were circulating through networks, that his actions were being reviewed by superiors who understood what he didn't yet, that this encounter would cost more than he could imagine. Donna made one final call before sleeping, to an ethics advisor whose opinion carried weight. The conversation lasted 40 minutes. The conclusion was cautious but clear. She could proceed with the Westbrook trial if she documented her ability to remain impartial, if she disclosed the arrest to all parties, if she demonstrated that personal experience wouldn't override judicial analysis. She would preside. She would hear the evidence. She would deliver justice that her own arrest had nearly prevented. The decision solidified as conviction. Not defiance. Not pride. But necessity. Because stepping aside would mean letting bias win twice. Once in the parking lot, and again in the courtroom. The video surfaced 36 hours after the arrest. Not through official channels, not through carefully managed press releases, but through the raw mechanics of social media. Uploaded by the woman in the parking lot who had recorded the encounter on her phone, shared initially with friends, then spreading outward with the exponential acceleration that defined information in the digital age. 10,000 views in the first hour, 100,000 by morning, 1 million by the end of the first day. The algorithm favored outrage, and this delivered it. A federal judge handcuffed in a parking lot, her credentials dismissed as possibly fake, her rights violated while traffic hummed in the background and onlookers recorded the dissolution of procedure into prejudice. News outlets picked up the story next. Local stations first, then national networks. The footage played on loop. Daniels approaching with his hand near his weapon, Donna's calm responses, the moment she presented her judicial credentials, the dismissal, the handcuffs closing. Legal experts were brought on camera to dissect the violations. Former prosecutors and defense attorneys weighed in. Civil rights organizations issued statements. The comment sections filled with thousands of personal accounts, other parking lots, other stops, other encounters where skin color became reasonable suspicion. Donna watched the coverage from her chambers. The video was accurate, which made it more damaging to the department than any testimony could be. Every procedural failure visible. Every constitutional breach documented. The kind of evidence that eliminated ambiguity, that made defense impossible. She filed the federal lawsuit 4 days later. The complaint ran 38 pages, single-spaced, with detailed citations to case law, statutory violations, and specific timestamps from the body camera footage that had been provided per her demand. Fourth Amendment violations, unlawful seizure, without reasonable suspicion. 14th Amendment violations, selective enforcement based on race. Municipal liability for failure to train and supervise. Claims against Officer Daniels individually. Claims against the City of Chicago. Damages sought for constitutional injuries, emotional distress, and punitive penalties designed to deter future misconduct. The filing made headlines within hours. Not just because a federal judge was suing a police department, but because the lawsuit itself was a masterclass in civil rights litigation, precise, thorough, devastating in its documentation. Every legal argument supported by established precedent. Every factual allegation backed by video evidence. The kind of case that city attorneys reviewed and immediately understood they couldn't win. Media coverage intensified. National outlets sent reporters to Chicago. Camera crews stationed themselves outside the federal courthouse, outside the police department headquarters, outside City Hall. The story had momentum. Judicial misconduct cases always did, but this carried additional weight because the victim wasn't just any judge. Donna Mullinax had a reputation. 19 years on the bench. Hundreds of published opinions. A record of fairness that made the arrest's racial bias impossible to dismiss as misunderstanding. Inside the police department, the internal affairs investigation began with the urgency of damage control. Daniel's service record was pulled. His arrest statistics analyzed. And patterns emerged. Disproportionate stops of Black residents in his assigned district, higher rates of searches and arrests compared to his peers, complaints that had been noted but not acted upon. The kind of data that should have triggered intervention years earlier but hadn't because systemic bias made individual bias easier to overlook. The findings were damning. Daniels was suspended within a week. The police union provided representation, but the video made defense difficult. The facts weren't disputed. The violations were clear. 2 months later, the termination came through conduct unbecoming, policy violations, failure to adhere to constitutional standards. His career in law enforcement ended not with criminal charges, but with administrative finality. He attempted an appeal, hired an attorney, prepared arguments about procedural errors in the termination process. But the union advised withdrawal. The case was unwinnable. The video had become iconic, shared millions of times, analyzed in law school classrooms, used as training material for what not to do. Fighting would only extend the exposure. Daniels left Chicago 6 months after the arrest. The details of his departure remained vague. No forwarding address publicized. No interviews granted except one attempted media appearance where he struggled to explain actions that were recorded and indefensible. He became a cautionary tale, a name associated with a kind of bias that departments claimed to have trained out of their officers but clearly hadn't. Meanwhile, Donna faced her own challenge in the courtroom. The Westbrook trial proceeded on schedule, but not without complication. The defense attorneys filed a motion for her recusal, arguing that her arrest created an appearance of bias, that she couldn't impartially evaluate evidence involving the same police department. The motion was well-crafted, citing ethics rules and precedent, raising legitimate concerns about judicial impartiality. Donna drafted her response over a weekend, 12 pages addressing each argument methodically. She acknowledged the arrest, acknowledged her own lawsuit, but distinguished between personal experience and judicial analysis. Cited cases where judges had presided over matters tangentially related to their own circumstances. Emphasized her 19-year record of impartiality, her published opinions holding both plaintiffs and defendants accountable equally. She concluded with a simple principle: recusal should be based on demonstrated bias, not on assumptions that experience precluded fairness. The motion was denied. Donna remained on the case. The trial proceeded with the same rigor she brought to every proceeding, evidence carefully weighed, testimony scrutinized, legal standards applied without favor. The verdict, when it came 3 weeks later, ruled for the Westbrook family. Excessive force found. Constitutional violations established. Damages awarded. Justice delivered not despite her arrest, but in defiance of the attempt to use that arrest as grounds to delay or derail accountability. The settlement discussions in her own case began during the trial. City attorneys reviewed the footage, the complaint, the evidence. Convened meetings to assess liability. Calculated the costs of proceeding to trial versus settling. The math was straightforward. The video eliminated ambiguity. The violations were established. A jury would likely award substantial damages, possibly punitive. Settlement was cheaper and less damaging to the department's reputation, though reputation had already suffered considerably. The proposed amount arrived through back-channel communications. $750,000. Donna's attorneys countered with $1 million. The city accepted within 48 hours. The settlement was finalized with standard terms: no admission of liability, confidentiality provisions, release of claims. Donna signed, not because she needed the money, but because the settlement itself was admission enough. Cities didn't pay 7 figures for arrests they believed were justified. And then came the Department of Justice investigation. The review had been triggered by the publicity, by the patterns uncovered in the internal affairs investigation, by mounting evidence that Donna's arrest wasn't isolated but symptomatic. Federal investigators arrived in Chicago with subpoena power and data analysis tools. They pulled 5 years of traffic stops, searches, arrests, controlled for demographics, time of day, neighborhood characteristics, ran statistical models to identify disparities. The findings were released in a 106-page report that detailed systemic racial bias across multiple indicators. Black residents were stopped at rates disproportionate to their population percentage, searched more frequently, arrested more often for discretionary offenses. The disparities persisted even after controlling for crime rates, poverty levels, and other demographic factors. The conclusion was unambiguous. The Chicago Police Department engaged in patterns and practices that violated constitutional rights through selective enforcement based on race. Recommendations followed. Mandatory implicit bias training for all officers. Civilian oversight boards with investigatory power. Body camera policies requiring activation during all public interactions. Federal monitoring for a minimum of 5 years. Sanctions for noncompliance. The kind of structural intervention that departments resisted but couldn't refuse when backed by federal authority. Donna received the report in her chambers. Read it thoroughly. Highlighted sections that echoed her own experience, that validated what she had known from the moment Daniels approached her in that parking lot. The arrest hadn't been personal. It had been procedural, the procedure of bias codified into practice, normalized into enforcement, perpetuated through lack of accountability. She made one decision immediately. The settlement money, all of it would be donated. Not kept. Not invested. Given entirely to organizations working on police reform, civil rights litigation, community advocacy. The amount was announced in a rare public statement, brief and direct. Systemic change mattered more than personal compensation. The money could fund lawsuits for people who didn't have federal credentials, could support oversight initiatives, could challenge the patterns that made her arrest possible. Donna thought about this sometimes in chambers between cases, during the quiet moments that judges rarely discussed publicly. The interconnection of injustice, how her arrest had nearly prevented the Westbrook family from receiving the trial they deserved, how one act of bias threatened to compound into further harm, how the system's flaws revealed themselves not just in individual encounters, but in the cascading consequences that followed. Her arrest could have derailed another family's quest for closure, could have delayed justice for months or years, could have sent a message that challenging police misconduct created conflicts too problematic to navigate. Instead, she had presided, had ruled based on evidence, had delivered a verdict that the facts supported, and in doing so, had demonstrated that experience could inform judgment without biasing it, That understanding injustice personally didn't preclude evaluating it fairly, that the system could work when people within it refused to accept its failures as inevitable. The video remained online. Millions of views, thousands of comments, ongoing shares and discussions. It would probably remain accessible indefinitely, a permanent record of an encounter that shouldn't have happened, that revealed patterns that shouldn't exist, that forced changes that shouldn't have required such dramatic catalyst. But the video also represented something more optimistic. Evidence mattered. Documentation could overcome denial. Publicity could generate pressure that produced reforms. Individual cases could illuminate systemic problems. And sometimes, not often enough, but sometimes, justice could be not just an abstract principle but a tangible outcome achieved through persistence, exposure, and refusal to accept that authority's abuse was beyond accountability. Donna closed the file on her desk. Another case. Another set of facts. Another opportunity to apply law fairly. The work continued. The reforms continued. The vigilance continued. Perfect justice remained elusive. But incremental progress was real. And the parking lot where she had been handcuffed would be remembered not just as a place where bias was enacted, but as the place where its documentation sparked changes that reached thousands of people who would never know her name but would benefit from the accountability her arrest had forced into being. That was enough. Not everything. Not completion. But enough to justify the fight, to validate the exposure, to demonstrate that even rare victories in a flawed system could matter. Could protect people. Could shift patterns. Could move the slow machinery of justice towards something closer to equity. The work was never finished, but it was work worth doing. Before you scroll away, ask yourself how this story would have ended without a camera, and if that question matters to you, subscribe and share your thoughts below.